get so mad, there's no controlling me. My thoughts get so bad, I'm like, I might grab a bat, I don't know. My wrath, my blood boils over like, oh God, here goes. I lost all feeling from my head to my toes. You said some shit that I can't let go, so just stay tuned for the rest of the show. So have you ever felt betrayed? Switches how you see things, realize something needs change. Cause I know you got me fucked up, let me show you what's up. Cause enough is enough. I'll take a face full of pavement just to make a statement. I know there's no turning back. Oh God, adrenaline wasted, so mad I can taste it. I know there's no turning back. I'll do what it takes, I ain't making mistakes like that. I'll put it on your face to make you go take it back. I'll lose my shit, I go crazy when I'm mad. And now you go wish you would shut the fuck up real bad. And now that I'm gone, yeah, I know there's no turning back. And now that I'm gone, yeah, I know there's no turning back. I don't fucking take smoke, I'ma poke a hole through you, choking's overdue. Come at me and you won't get any older, dude. Crack your holder too. Heating up inside of me, blood so violently. Thanks for trying me. Now it's finally time to see how this rivalry becomes a dynasty. I know there's no turning back. Oh God, adrenaline wasted, so mad I can taste it. I know there's no turning back. I'll do what it takes, I ain't making mistakes like that. I'll put it on your face to make you go take it back. I'll lose my shit, I go crazy when I'm mad. And now you go wish you would shut the fuck up real bad. And now that I'm gone, yeah, I know there's no turning back. And now that I'm gone, yeah, I know there's no turning back.
They call me a god. They call me a god. They call me a god. They call me a god.
Let's go. I'm about to go off like a weapon. Fuel to the top, got a filled up engine. In my thoughts, obsession. I will not stop, no, I'm never second guessing. I got a God complex. Haters love to hate, but I never feel pressed. Got a lot on my plate, but I never get stressed.
Hello, hello. Hold on. Stupid. Hello, my good people. So, Johnny Boy filed some motions, and let's take a look here. I wonder why he's filing a motion. It doesn't make sense to me. He's been his attorney for what, 20, 4 years? It'll be 4 years in June. I think there was like 4 motions, I think. Sorry, I was ready, but my laptop crashed on me 3 times. Trying to set this up. I don't know what to do no more. Okay. Jeez, when you go look at their documents, it's like a mile long. Whoa. Okay. All right. So look at these documents. All right. See, I'm sorry, you guys. Something's wrong with my laptop. I don't know what to do no more. Let's see, which one do I want to look at? All right. Johnny Boy. This was filed January 11th. So yesterday, let me pull up my chat here. Oh, I hate hearing my own voice. All right. Let's make this bigger. Well, this bites. All right. All right. Declaration of Counsel in support of motion to withdraw. I'm currently the counsel for Chad. I have exercised due diligence in seeking capital qualified attorney that could serve as a co-counsel on this case, but none have been able. Hold on. Okay. But none are available. As a result, I have acted as sole counsel on all aspects of representing Chad in this case and have fully expended the retainer of the case in providing representation for Chad. Here we go. Okay. After speaking with Chad, I have confirmed that he's unable to pay for any additional funds. I was wondering when that money was going to dry up. And the thing about it is, didn't Johnny Boy buy his house? If anybody knows, please let me know in the comments below or in the chat. He believes it would be a disservice for me to continue to represent him in a capital case and trial without compensation. So what is he going to get? A public defender then? He further seeks the appointment of 2 capital qualified attorneys to oh my God, you guys, hold on. I got a cough. Hi, Grandma. No, Grandma, this here is breaking news. Yes, this is breaking news. It has to do with Chatty Boy. No, we're still doing 905. I got to send you the documents. I just found them again. All right. So then it says here, so he needs 2 qualified capital attorneys. What does that say? I convinced an attorney from Boise area to petition to become a capital qualified. However, this process, even after significant amount of time, he has not been approved by the Public Defense Commission. Oh boy. The time to have meaningful by co-counsel has long passed. At the present time, even asking I work 24 hours a day, 7 days a week, could not complete the necessary tasks to represent him. It is no secret or surprise that the Public Defense Commission lacks a necessary number of capital qualified attorneys, which is true. I do agree with that. In Idaho, in this state, to effectively represent all the needs. Now remember, you guys, the state, the prosecuting attorney, Do you remember that they had a lady come from another state to help them with this case, with Lori's? Do you remember that? Yeah, prosecutor. Yeah, so I can't remember her name. I did a thing on her. Don't worry, we'll get to it. So this is kind of odd. Therefore, the consent of and the request by Mr. Daybell for counsel, I hereby withdraw from this matter. I declare under penalty of perjury to the law of state of Idaho, and it was yesterday. Holy crap, people! Yep. Why don't I remember her name? See, I've been having a lot of problems, you guys, with my memory. It's really, I don't know what's going on with me. Okay, Idaho. Shoot. Okay, I'm not going to look right now. Let's get through these motions. Sorry. Maybe it'll come to me. Oh no, he's so full of crap. And the lawyers are like, no. And no, I found it really interesting because he has not had help. Because a case like this, he should have more than one attorney. He's been waiting for the commission to okay the guy he did find. But however, no, not Lindsay Blake. She came from another state. The state got to do it, so I don't understand why Chad can't. They're violating his rights, right? Do you agree with me or not? It's the same prosecutor for both of them. It's Lindsay Blake, there's Rob Wood, and then the third one. And so, oh my God, I'm just going to continue. I'm forgetting. If you know what I'm trying to say, Grandma, can you put it in the chat for me like you do? Thank you. See, Grandma here's she's my brain sometimes. Okay, this one is well, this one's a long one. Okay, there's a motion. Is this in order? Hold on. Okay, it is a different one. But there's one good thing that came about Johnny Boy doing this, okay? Which it didn't happen. You know what they've been doing forever? All the little secrets out there in Idaho. We can't know nothing. Well, shit's going to be unsealed. Finally. Here we go. Here's the motion here. Let me make it bigger. Oh. This is motion to withdraw. Okay. It's not the same one that we just read. He's been the counsel since May 25th, 2021. And plus a previous case, which we know that it's not there no more. Undersigned counsel has undertaken a sole counsel all matters, including obtaining, reviewing, discovery, conducting investigation, hiring, and working with numerous Oh my God. Yeah, I didn't think about that, you guys. Wow. Okay. Chatty retained undersigned counsel with personal funds. At a hearing of At a hearing on January 19th, 2023, the court inquired Chad and declared him indigent. Chad does not have the ability to pay for counsel continuous services, and Chad seeks the appointment of 2 capital qualified attorneys to represent him in this matter. Yep, yep. All right. The court is aware this case is both extraordinary and complex, and prosecution is seeking the death penalty, which requires counsel to prepare for 2 trials. Okay, we'll look at that too. Motion to continue the trial date, enforce Dable's constitutional rights. Reflecting this complex and the work required to prepare and try this case, this court has set aside 2 full calendar per trial, and the prosecuting attorney consists of no less than 5 attorneys from 2. What? Wow, I didn't know that. 5 attorneys from 2 county offices, including the out-of-state one. See, I knew about her, but I didn't know there was 5. That's interesting. Lindsay Blake is on it, yeah. Remaining on this case would require undersigned counsel to work around the clock, more than full time, in more than 4 months without compensation and without the assistance of any other counsel. This motion is made Chad's full consent. Chad has requested for me that he be given 2 capital qualified attorneys at his trial. I have made diligent effort to find a lawyer to assist in this matter for a significant amount of time. The attorney who I located and agreed to get qualified has not been, like I just said, approved. Let's see. The time for him to be any assistance to me in preparing for this trial is long gone because Chad is facing the death penalty. Okay, we just read that. Sorry. Okay, I read that. Let's see. Why do they have 2 of them like this? I don't get it. Sorry, guys. It was like kind of like a repeat and kind of not. So there's that. But because of this happening, and he's got 2 court hearings next week. And we'll look at that. I was wondering why I got a notification. Lawyer speak? Me? I'm not no lawyer. Order to unseal documents, you guys. How exciting is that? On January 11th, the court received a request from defendant Chad to file a motion to withdraw as, what is that? That don't make sense. Okay, maybe it does. Motion to withdraw as counsel under seal and permitted to motion to temporarily seal for further review. The court has reviewed the motion to seal, declaration in support of the motion to seal, underlining motion to withdraw So the court had to figure out, like we always been hearing, that they wanted to make sure it was, what's the word? What do they say, you guys? Judicial efficiency and fair administration of justice. The court has determined that the motion to seal is not recognized as an extant record under the law. Further, it is reviewing the request to seal and underlining motion to withdraw. The court finds that interest in the public disclosure prevails over any claimed privacy interest in the file's pleading. As such, the court directs the court clerk to file motion to seal, the motion withdraw, declaration in support to seal to the record and publish documents. Okay, the motion to withdraw is January 18th at 10 a.m. No, wait a minute. Did I read that wrong? Hold on. Okay, I read it right. I had to take a double take. The way that I know, it confuses me. That don't take much. He's asking the court to let him go off the case. Motion to withdraw from the case. Yeah. There is 2 hearings next week. Hold on. I'll find the other date. Let's see. What's this one? Okay, on the 18th at 10 a.m. When's the other? I thought I seen that. Okay, I guess not, guys. I was wrong. It happens. Yeah, but I thought I seen another one that said a different date. Hold on, let me look. Hold on, I'm looking. Oh, okay. All this is happening on the 18th. You want to go through Oh, where's Miss Barbara? Well, you know what? I bet you that trial is not going to start in April now. Nope. Hi, Miss Barbara. How are you, my sweet friend? All right. Well, I'm just going to skim through this one here. I knew he didn't win that decision. Okay, motions to strike the death penalty. All right, what does it say? They filed it on November 9th, 2023. The state objects to the motions on November 29th, 2023. See, look at all these little secrets that they do. Having fully considered the record, briefing, and arguments offered in support of the parties' positions on motions, here are the facts. Let's see. Okay, they talk about, when they were indicted, Chad and Lori. Then they became, and plus Tammy, can't forget Tammy. And it was under a single indictment. You guys remember that? Okay. Okay, for Lori, they said that she was not legally competent to stand trial. And so it was stayed for an extended period of time. There was no issue or delay occurred in Daybell's case. Okay, that's funny. Now, if you guys remember, Johnny Boy said he was ready to go right away. Remember that? He said he didn't need time, and then all of a sudden he did. And I think it came because of I could be wrong. He wanted his own experts for the DNA. What's going on? I'm okay. Motion to withdraw was objected to. So now the hearing about the attorney. Oh, he's got it. There's no doubt. Who's that? Are you talking about Lori? The queen of the her 4-4? Grandma, you want to laugh? Okay, Miss Barber, you want to laugh? I've been covering this case for almost 4 years. You know how Chatty thinks he's a god.
They call me a god. They call me a god. They call me a god. They call me a god.
Let's go. I'm about to go off like a weapon. Fuel to the top, got a filled up engine. In my thoughts, obsession. I will not stop, no, I'm never second guessing. I got a God complex. Haters love to hate, but I never feel pressed. Got a lot on my plate, but I never get stressed.
Yep. That just happened, you guys. Sure did. Okay, I'm going to put this up real quick. I have to get something out of the oven. I'm so sorry. But this was a last minute thing. This came up. This just came up. Hold on. Okay, I'm back. Let's see comments here. Must be talking about Lori. He is a twisted narcissist. Oh yeah, definitely. I think they're gonna continue. Yeah. So I want to see what else they have to say here. Okay, Bella's case was stayed, which we knew. No such issue or delay occurred in Chad's case, nor has he ever been determined to require such treatment. Further, Bella refused to waive her constitutional rights to a speedy trial, which concurrently Chad filed a written waiver of a speedy trial. See you guys, remember? And it was August 19, 2021. Finally, third attempt, Chad successfully moved this court for and obtained severance of trials from his alleged co-conspirator, Lori. Why are they saying alleged? It's not alleged no more. She's convicted. Just saying. I bet you don't, because Johnny Boy, he gets really red in the face. I bet you he's so stressed out. No, I didn't make nothing. I don't even feel good to eat right now. I'm so stressed out. But that's my problem. Well, you know what my dad did for me? And I'm going to tell you this. My dad knows I love sugar cookie ice cream bars, which they're very expensive at Christmas time, whatever. He bought me 14 boxes. And I said, no, I'm only I put 5 in my freezer for now, and he's going to hold the rest for me. He goes, yeah, don't take this the wrong way. This is what he said to me. He's funny like that. He goes, so you can get a bigger ass than you already got. No, because I've gained so much weight. And he's not lying. He's not lying. I want ribs and beans. Guess who's making that? Our girl, Grandma. Okay, let me go back. Okay, finally, on his third attempt, Chad successfully moved the court and obtained a severance. Oh, I already read that. So they both had the seeking the death penalty. The state has not withdrawn this notice following the severance of Daybell and Bello trial and the continuance for Chad to review additional discovery. See? Conducted additional DNA testing. See? Okay, I got it right. It's been a while. Lori's case proceeded to trial without the option of the death penalty after the court struck a death penalty as sanction for late discovery to Lori's defense team. The sanction was ordered based on the voluminous discovery having been provided to the defense eve of the trial. What? Really? And beyond. The court scheduled deadlines to do so, where Lori forged ahead with their trial settings, refusing to waive her speedy trial right. All right. Court made findings predicted on procedural due cause and carefully weighed fundamental rights in reaching the decision. The decision did not consider nor was analysis in reaching the decision. Oh, come on, look at this. Predicted on determination and constitutional of the death penalty. Importantly, at the time court made a ruling, the court stated that the ruling applied just to Lori. Chad was provided his equal remedy of additional time for voluminous discovery disclosures and to test the DNA prior to trial. On March 21st, 2023, court issued a written order expressly indicating that motions founded in the constitutional argument were rendered as the ruling was sanctioned. Hold on, I gotta take a break. I'm gonna look at the comments. The chat can say his case is taking too long. It violates his. Yeah, but he chose not to. He did. He's going to be Superman. He's going to think he's Jesus Christ in there. You can send me some. That's what I said too. He's a sugar fan. Additional time because they're taking so long. Yeah, and also because at the last minute, they said they found DNA. And so he wanted to have his own expert do their own testing. I'm eating ice cream and it's freezing outside. Yeah, we got some bad weather coming here too. All right. Chad's trial was scheduled for April 1st, 2024. How about that? And on November 9th, 2023, Chad filed the instant motions requesting the court to strike the death penalty. On August 22nd, 2023, the state filed objection to the motion. On the 29th of November, the court heard the parties in argument and motions that took the matters under advisement. Let's see. This is all the blah, blah, blah stuff, which I'm not going to read. You know how they do that. And they tell that what they're violating. Okay, Chad's two motions request a court order to strike the death penalty as a potential sentencing option. The state objects to both motions. The court will discuss each in turn. Okay, Chad's first motion argued that the state of Idaho theory of the case is alleged co-conspirator Lori is more capable than Chad. I remember that. The motion then argues that Chad should not be subject to the death penalty because the state argues that Lori was more culpable and Lori was not subject to the death penalty. The state argues that the motion to strike the death penalty are not procedural right for review, and further argues that the merits the motion to strike penalty based on exculpatory of Daybell versus Vallow should be denied. Considering the brightness of the motion to strike, with respect to culpability, the court agrees that the state of Idaho has clearly established procedure for cases where capital punishment is a potential outcome. A two-phase trial is employed, a guilt phase where a jury sits in judgment and the facts deliberates to reach a verdict of guilty or not guilty of crimes charged against the defendant. If the convicted on crimes that carry potential of the death penalty, is this supposed to be petite, you think? I don't know. Jury then hears the evidence aggravating and mitigating factors by both the state and the defense before deliberating again whether or not they find a statutory aggravating circumstances. No mitigating circumstances. All right, I gotta take a break. Chad looks like a frog. Do you know that song? Do you know that song? Jeremiah was a bullfrog. Something like that. I don't know. Confusing. They want to. Yeah. It means petty. Okay. I never seen or even heard of a word like that. I should do video of Chatty Boy. Chatty Boy was a bullfrog. He was no. How would I do that? I can make up lyrics. I love music. My life. Every song has a meaning in my life. Okay. Why can't they just say that then? Why do they gotta say this stuff over and over and over? I don't get it. Okay. Chad is asking that the court to, oh God, here we go again, free something, the maximum potential penalty of death before a trial jury has undertaken any deliberations about his guilt of crimes charged or heard any evidence whatsoever. And then they talk about U.S. Supreme Court holding ring case. Okay. Turning next to other arguments, Chad relies on, what is that, citations? I don't know. From the transcript prepared at the fellow trial, the court has reviewed those quotes and determines, as the state contends, that they are largely taken out of context, otherwise incomplete to their presentation. Beyond this, Chad overlooks one important consideration. The court cannot and will not speculate about the evidence at Chad's trial. Will be with respect to Chad to make pre-trial determination whether Chad is more, less, or equal to Lori, who now has been convicted of all charges. It would require the court invade province of the jury and make premature decisions about the facts of Chad's case, not Lori's. The court declines to do so and finds that the request is not right for judicial determination because the state has not yet put their case against Chad. Additionally, while the court believes there is likely to be considerable overlap in witness and evidence for Chad's trial, the indictment charges Daybell with separate and additional crimes. Really? Oh, yes. Well, kinda. Fraud of the kids' Social Security and for JJ, he's special needs. He was no friend of mine. Every time I heard a word, he said, hold on, my eyes went blurry. He said, lied. That can't be a start. Okay. Okay, he talks about the overlap. Okay. Okay, they already talked about it overlapping. Okay. The court has carefully reviewed the cited authority by Chad and the state and finds that the case law does not suggest that degrees of culpatory and approximately determined by the court ahead of trial. To do so, oh my God, look at how many pages this is. To do so, defy the fundamental right to a fair trial by jury of one of his peers. Facts submitted to the trial may only be considered after the admission of evidence, testimony within contrast with evidentiary rules. Thus, while Chad is charged with co-conspirator on some counts of the indictment, he is nevertheless charged with first degree of Tammy, a crime that is punishable by death. Chad alone faces the count of potential of his conviction for the separate murder, distant from Lori's convictions. Further reveals that the determination of speculative and considered before trial. Chad's argument and relative, it's not persuasive as a basis to strike the death penalty. Okay, moreover, I'm just skimming through this, you guys. It is the duty of the jury, not the court, to determine the facts of the case, including deliberating about whether the state meets its burden to provide beyond reasonable doubt that Chad is guilty or mirroring changes against Chad and Lori. Oh my God. The court finds no bias to strike death penalty or arguments of relative compulsory. What is that word? The state has complied with a statutory obligation having timed, filed its notice intent to seek the death penalty, which indicated on multiple counts. The motion is therefore denied. Denied. Okay, and this one has to do. It's the same thing that I just read. Why did they do it 2 times? Yeah. Okay, so they're just pretty much talking about Lori. Yeah, it's being said more than once. It's weird. Yep, sure has. Okay, conclusion. For ongoing reasons, Chad's motion to strike the death penalty based on whatever is denied. Motion to strike the death penalty as arbitrary, curious, in the light of striking. Oh, see, and it talks about Lori. Okay, that was denied. There you have it. Okay. Teddy was a bulldog. He wasn't no friend of mine. I knew every single word he said. That's this one. It's a bullfrog. He was no friend of mine. Every time I heard a word, he said he lied. That can be inserted. Okay. Yeah. Yeah, we'll figure it out. We got to. We got to make fun of Chad. It's his turn once again. Oh, my eyes are on fire. What is going on here? What are you guys doing? We are doing a live tonight at 9:05. And Grandma, I will send you the documents. By the way, we're not going to get through it all. We're going to have to do a little bit at a time. We are going to watch his when he got arrested. We are going to watch other stuff, to kind of catch us up. I don't know why this man is being charged, but it's 44 pages. So that's okay because it's a new trial we're talking about. So what we could do is when we're watching the trial and they go on like break, we could go through them. I don't know. Yes, that would be your time. But I want to thank you guys for being here. And as you can tell, I was struggling with my words today. I mean, I do it anyways, but today's been bad. I don't know what's going on. Yes, day 1. I was trying to find it. I had a bad night. Oh, Miss Barbara, do you want to know what happened that night when we talked? Well, you know how we always say, well, we're going to get going, but we don't get going? Well, what ended up happening like a half an hour prior, I took my medicine when I go to bed. That's what happened. I'm like, no way when I got up. I'm like, oh, God, how embarrassing. It's okay. I'll help. Thank you. They did have a thing where you had like a Siri voice, but some work and some don't work. Okay, I'm going to go lay down for a little bit, and don't worry. It's only going to be for an hour. Okay? Okay. Love you, Miss Barbara. Love you, Grandma. See you at 9. Well, I'll come a little earlier, duh. And Miss Barbara, if you want to be on the panel too, if it's easier for you, come on up. Come on down, Graham. Come on down, Miss Barbara. All right. Love you guys.